You're up.
Good morning, Your Honor. May it please the court, I'd like to reserve 5 minutes for rebuttal.
Sure.
I represent Virginia Miro regarding this appeal. The Second District Court of Appeal reminds us that the courtroom may not be used as a convenient vestibule to the arbitration hall so as to allow a party to create his own unique structure combining litigation and arbitration. The issue for this court is whether Freedom Boat Club's invocation of the litigation machinery in the form of a federal limitation of liability lawsuit waived its right to arbitrate any claim between itself and Virginia Miro. Now,
Mr. Munch, let me ask you something. I'm not aware that, say, take AAA, for example. I'm not aware that they have a process or procedure that would allow the boat owners to have brought a limitation of liability action in an arbitration forum.
well, we'd have
Am
to
I
look.
missing something?
Well, there's nothing. In fact, if an examination of the arbitration clause in this case says any dispute between the parties, that would include tort claims, anything at all.
But when you
our
bring the
position-
liability limitation action, it is not technically against a particular party. It is the invocation of a statutory maritime right that limits all damages for anyone in the world to the value of the ship.
Your Honor, it is a proceeding which mandates that anybody that has a claim regarding that particular casualty file a claim in that court, or it will be forever barred. And then it would continue on the federal court to decide issues of 1, liability, whether the ship owner is exonerated, 2, whether the ship owner gets to limit its liability, and 3, whether there are damages. For example, when the Summit Venture hit the Skyway Bridge, the ship owners filed a limitation of liability action.
And of course, that is done. My recollection is a little foggy. That is done before anyone has asserted a claim.
Well, not necessarily, Your Honor. In order to invoke the Federal Limitation of Liability Act, it has to be done within 6 months of the first written notice of the claim. The ship owner in that case, I believe, filed it right away because the federal limitation action has the ability to require everybody to file claims or be barred. It's called a concursus.
I understand. But there is no, are you telling me that the limitation of liability action could have initially been brought in an arbitration proceeding?
I am respectfully saying yes, Your Honor, that the arbitrator could have decided all issues. That is what the arbitration clause in the contract said. It decides all issues between Miro and Freedom Boat Club.
But that position seems to fly in the face of what appears to be a good body of federal case law.
Respectfully, Your Honor, the only cases in front of this court are Yang, Nagliati, and Ballard. And those cases, in fact, there's been no case cited to this court which says that limitation of liability can't be decided by an arbitrator panel.
But the limitation of liability action courts have held is indeed a defensive move.
Well, and in fact, the trial judge said this is a limited action. It's really not a limited action because even though the ship owner is the plaintiff, the trial court, which would be the federal district judge, non-jury, would decide all the issues, liability, fault, and damages. So it's a mechanism to bring all claimants, if there are all claimants. In our situation, there was only Miss Miro, but it has been termed a defensive action but it is a method of completely disposing of the case. In other words, in this situation, if I hadn't invoked the single claim exception, which is a method to get back into state court, we would not even be here. There would have been no state court action, and the federal judge would have decided all issues between the parties, liability and damages, and arbitration never would have come up.
All as part of a claim filed in the limitation of liability action.
What was part of it?
That would have been done all as part pursuant to a claim that was filed within the limitation of liability action.
Yes, Your Honor, that is correct. That would have all been resolved. There never would have been any arbitration at all.
Well,
And
tell me,
that's
Mr. Munch,
my point is that
what was the involvement of Ms. Miro in the federal action, if any?
she had involvement. The involvement is that the ship owner filed its limitation petition. Then the court enters an injunction barring any other lawsuits against Freedom Boat Club. At that point, it issues a monition requiring anybody that has a claim to file a claim. Ms. Miro filed a claim in that action, and in response to that claim, Freedom objected to the claim, filed affirmative answers to the claim, and never raised arbitration, even at that point, to Ms. Miro's claim.
And then after a period for filing claims expires, you're the only claimant standing, and because of that, you can transfer to state court.
Yes, Your Honor, under the Supreme Court cases, because of the single claim rule and the Supreme Court's recognition under the savings to suitors clause that they will allow people to have a jury trial, I opted to go that route.
When you transfer to state court, is it a transfer, or do you get to just file a new action in state court?
No, Your Honor, that's a good point, because
I try.
the federal case is stayed. I have to stipulate, even if I win in state court, Freedom has the absolute right to come back into federal court and have the federal judge decide de novo all issues on limitation and exoneration. So it doesn't end with me trying my case to jury trial in state court. That is the stipulation that's ordered by the judge. That's the very last, that's the 18th or 17th docket entry by the federal judge, that Freedom, even if we arbitrated now, they would come back.
That was my next question. That would apply even to an arbitration decision.
Yes, Your Honor, because we're not done, even if this court upholds the state court trial judge's order sending us to arbitration. We can go back and they're going to have another bite at an apple. And
is there a case law, or is there law that gives the result in state court under this scenario any sort of weight with the federal decision maker?
No. In fact, I have to, as part of a stipulation that I have to file in the federal court in order to get this injunction lifted, I have to stipulate as the claimant that the federal judge reserves all rights to decide it de novo regarding limitation and exoneration.
The federal judge retains that ability. That does not require the federal judge to exercise that authority. If it goes to arbitration, I suppose a federal judge, if that's where it has to go back to, could probably just confirm the award under the Federal Arbitration Act.
The judge could confirm the award. Yes, Your Honor, but what is happening here is that they're doing the exact thing that the Florida Supreme Court said was inconsistent with the right to arbitration. They're blending arbitration and litigation. If Freedom wanted to arbitrate this case, it could have waited till Virginia Miro filed a lawsuit in state court, raised arbitration. That would have been the end of it. It would have been gone to arbitration, case decided completely by arbitration. However, they invoked this federal limitation of liability machinery, and now we're dealing with a blended method of resolving this claim.
Mr. Munch, let me ask you this, because I know at the beginning you've indicated that by virtue of the appellees bringing this limitation of action, you're taking the position at that point they should have raised the issue, or within that claim, they should have brought the issue of arbitration. Let's just set that aside. When your client brought her claim, when she did in order not to lose her within the window period, I want to make sure that I understand this, that in response to her bringing that claim, as I understand your position at that point, as part of the answer from defenses, they should have raised that this issue should go to arbitration, and they failed to do that. Is that what I'm hearing you say?
That is correct, Your Honor. That is part of, because the Supreme Court and the Second DCA tells us to view the totality of the circumstances when ruling on a waiver. And that should be included in the totality, because Freedom at that point, it could have put in a sentence as an affirmative defense. This matter is subject to arbitration.
So, because in looking at the case law from our court, and I'm looking at the Chaikin case, and this is the language from there, that a party acts inconsistently with the right to arbitration when that party actively participates in the lawsuit by either prosecuting or defending issues that are subject to arbitration. So using that language from our court, that forget the first part, because I haven't seen any cases, quite frankly, Mr. Munch, that say that when somebody brings a claim, a limitation action, that somehow they have to bring up this issue of arbitration. I have not seen any cases to that effect. If you have them, I'd love to see them. But let's just go to the next step. So when your client brought that claim, the question for us, by virtue of Freedom filing their answer from defenses and not having raised the issue of arbitration, does that, under Chaikin, is that acting inconsistently with the right to arbitration? And that's for us to consider whether or not this is deemed a waiver. This is the analysis that we're going through?
That is one part of it. It's our position that even by filing the limitation of liability action, that is inconsistent with safeguarding its right to arbitration. However, the secondary position is that even if the court were to find that there is a right to file a limitation of liability action, once a claimant files a claim and there is a right to arbitration between them, and that right is not safeguarded at that point, that constitutes a waiver. That's my argument.
Is it worthwhile to, given that the federal court in the limitation action could proceed to essentially try the claim with the defendant's defenses and so forth, is it in that vis-a-vis the whole arbitration issue or arbitration waiver issue, is it any different than, say, a federal diversity action on the tort claim?
No, it wouldn't be. I mean,
so if essentially you are legally compelled to file your claim in federal court, essentially, but assume the plaintiff had filed the claim in federal court as a diversity claim, at that point, the defendant would be required to assert its right to arbitration or waive it, right? I mean,
absolutely, Your Honor. The little wrinkle is in this situation, because of the limitation of liability situation. I don't believe it's a wrinkle. In fact, the Ballard case that I cited, which was a District of Rhode Island case in the brief, says that the actions of the ship owner in that situation in failing to demand arbitration at the outset were inconsistent with the limitation of liability proceeding.
But how do you respond, Mr. Munch, to the other side saying by filing a limitation action, it just simply, you're not going into that this is a limiting thing, that you're not really trying the whole thing. But then how does that reconcile with Judge Northcutt and Judge LaRosa's questions that by filing a limitation of action, at that point, I would imagine a lot of discovery will take place, a lot of issues will be brought up, or is it simply, this is a right that we have, I am exercising that right, and that's it? I mean, is there more to it? And I'm just
Of
trying to
course.
understand.
Yes, Your Honor, I understand. That is the entire case between the parties at that point. That is the entire case. All of the defenses, it's essentially a full-blown trial, and the federal judge is going to make decisions, whether there was fault and whether there was damages. And
Mr. Munch,
Because
at
the point of the
beginning-
limit, I'm sorry, go ahead,
At
Judge
the
Lewis.
beginning, the federal statute requires the petition to be filed within the 6-month period, where you lose, as the ship owner, you lose certain rights that are available for maritime law. And I'm puzzled as to whether that statute anticipates that such a petition could be filed in an arbitration setting.
I don't know that the petition could be filed in a limitation setting. However, the issues could be raised. In other words, you can plead, and this is Supreme Court law, that you can plead limitation of liability as a defense in a state court action. You don't have to file it in federal court. Federal court has the benefit, if there are multiple claims, of bringing all of these claims into one jurisdiction in order for the court and the defendant to go through all of these claims and try all issues of liability before that one judge, rather than having.
You're into your rebuttal time. I just wanted to give you a heads up. So,
Your Honors, I'm going to go back to rebuttal time in a minute. I would like to just wrap up by saying the totality of the circumstances makes us look at what happened here. And we don't have to show that there's been any prejudice to Ms. Miro. That's the Saldukas case. We don't have to show any prejudice. All we have to show is that Freedom acted inconsistently with its right and failed to safeguard its right to arbitration. Freedom didn't have to do anything here. They could have waited for Virginia Miro to file a state court lawsuit or federal court lawsuit and raised arbitration at that point, and that would have been the end of it. However, they're the ones that invoked the litigation machinery, and they're the ones that actively participated in a discovery schedule in federal court, and therefore it's our position, respectfully, that they have acted inconsistently with their right to arbitrate. Thank you.
thank you, Mr. Munch. You got about 2.5 minutes left.
Yes, sir.
Mr. Gambach.
Good morning, Your Honors. David Gambach on behalf of Freedom Boat Club. May it please the court. I'll respond as briefly as I can. And let me start by answering the question about raising limitation in an arbitration proceeding. You can't do it. And the reason why you can't do it is the arbitrator won't have the same powers of the federal court to direct people to come in, not just people that are signatories to the arbitration agreement, but the entire world, as Your Honor had mentioned. That's the point of the limitation, is get all the claims in one spot. Let's see what they are. Let's see what we have available. And the issues of limitation, which come back again and again, is twofold. One is, what is the actual act of neglect? Not necessarily liability for it, but what is the actual act? And then separately, does the ship owner have privity or knowledge of that act? So if somebody else could be responsible, for example, the captain is not necessarily, his neglect is not necessarily going to translate back to the ship owner. So
But at that time, Mr. Gambach, when the action is filed, I'm assuming everybody knows the only potential claim is that of Miss Miro. Is that right?
Well, there was somebody else on the boat who might be able to make a claim. He did not. And in these situations, typically there are potentially other claimants out there. You don't know until you've done the publication and the notice goes to known potential claimants.
But we know Miss Miro is a potential claimant. Why, in filing the action, could they not, as Mr. Munch suggested, just put in a sentence noting that there's, at least as to this one potential claimant, there's an arbitration agreement?
Frankly, it just doesn't seem like it's the right spot to do it. And actually, one of the cases that we're talking about, there were 4 cases in the briefs below that talk about limitation in this context. One of them noted that it's inappropriate to bring a motion to compel arbitration in a limitation proceeding. And the one case
Well, I'm not
that,
talking about
Mr.
bringing the
Lynch-
motion. I'm just talking about reserving the right to go to arbitration if and when Ms. Miro gears things up.
I don't suppose I have a great answer for that, other than it simply didn't occur to me that that would be necessary in this setting.
So, Mr. Gambish, if that was not appropriate at that setting, how about subsequently when she brought in a claim and then your client filed answers from defenses? Why not raise the issue of arbitration at that point?
It's not technically an answer in affirmative defenses, though it appears that way when you look at the formatting of it. It is an objection under the applicable rules. And at that point, when you see there's only one claimant, you know what's coming next is going to be Mr. Munch's single claimant rule motion. It's really a formality. We knew what was going to happen in terms of the mechanics of the lawsuit moving forward. If he was going to make a single claimant rule motion, we would get into state court and have the opportunity there to raise it properly, as we did.
But doesn't the case law say, if I may, because under the cases, at least the state cases that we're following, that at any time to bring to the attention of everyone, this is an arbitrable case. We are going to proceed with our request for arbitration. We're going to, and when I quoted the language from one of our cases as to whether a party acts inconsistently with the right to arbitration, it seems to me that you had a great posture at that point in time. I could appreciate the fact at filing of the limitation action, there's really no case law on that, and I'll grant you that. But for the subsequent one, doesn't it make sense that at that point in order to preserve or in order not to be deemed, let me put it this way, in order not to be deemed that you've waived the right to arbitration, why not bring it? It's the very first opportunity to bring people on notice that she is bound by an arbitration clause, and we're going to be able to proceed with that.
I suppose it could have been raised as a footnote or something like that in that Rule F8 objection. It's Rule F8 from the federal rules, but it wasn't. I concede that point. But I bring it back to the cases that we're talking about. 3 of the 4 talk about a limitation action as not being a lawsuit. One case that wasn't addressed in the reply, the Sandbar case, specifically says a LOLA is not a lawsuit. In that case, was not a lawsuit against Mississippi, but rather a defensive action, and describes the LOLA as so thoroughly defensive as not to fall under the 11th Amendment in that case. You've got the Nakliti case as well that also says it's not an affirmative action, it's a defensive one, and the Yang as well says that. And Ballard, the only one that suggests otherwise, is fundamentally different. It's a case involving 500 claimants. It's a case where the actual litigation of a limitation action proceeded for some 8 months before an effort was made to raise the limitation issue. And they were trying to call out 1 out of 500 claims for arbitration. So I think you can distinguish the Ballard case from the others, all of which suggest that limitation action is not a trigger for the arbitration.
And Mr. Gambish, and in looking at the limitation action here, I'm looking at the language. The language of the petition is very broad and basically seeks exoneration of any potential liability whatsoever, as well as an injunction. So this is not just limiting the amount of liability to the value of the boat. So why not at that point an argument could be made? Because I just pulled it right now and that kind of jumped out at me. How do you respond that because you're seeking exoneration for any potential liability, not just simply for the value of the boat, that at that point, it is an affirmative request that maybe bring the issue of arbitration at that time?
Well, in the actual filing of the complaint, there's not really a mechanism to do that. When you look at what a limitation action is, yes, it's often brought with a request for exoneration, but it's not asking for affirmative release in the form of money, which is what the cases that we've talked about earlier. discussed, that there's not at the end of this, there's not going to be any sort of award coming to the ship owner. It would be, hopefully a finding of exoneration, if not that, a finding of limitation, that we're limited to the value of the post-casualty value of the boat, which in this case I think was around, I say 30 grand, something like that. But it's simply our view that because of the defensive nature of a limitation action, the request for arbitration was raised at the first appropriate juncture, which was as soon as he filed a complaint, as soon as Ms. Miro filed his state court action. The initial response to that was a motion to compel the arbitration that she agreed to do. And beyond answering your questions, I don't think I have anything further in terms of a response to Mr. Munch's arguments today. I would stand on the completion of our brief there.
Okay. Thank you, Mr. Gambach. Mr. Munch, you're up.
Oops, you're muted.
You are
Mr.
muted.
Munch. You're muted.
Ay, caramba, sorry about that.
We do it all the time.
Every day, probably. I'm sorry.
Mr. Munch, can I piggyback that very last question that I asked Mr. Gambach and help me out? And looking at the actual language that they filed in the list limitation, that the petition itself to seek exoneration of any potential liability, isn't that, could be argued that that by itself is some sort of relief to trigger or to make a request for arbitration? I'm just trying to understand all of this.
I would agree, Your Honor. At that point, they are seeking to be absolved of any liability. It's not, this is a procedural mechanism to have any cases or claims litigated against that defendant in that federal court. It's a kind of a mechanism almost of forum shopping in this case, because Freedom chose to file that limitation of liability action. They get a federal judge deciding the case, non-jury. In fact, in his objection, I raised a jury in my claim. In his objection, the appellee had a whole paragraph about objecting to jury trial. We filed our claim. There was no mention of arbitration. Once I go outside of the limitation proceeding and I ask for a jury and I'm entitled to a jury in state court, then the arbitration issue gets raised at that very first instant. So I would respectfully submit that this is a way, if I hadn't raised the state court single claim exception, we would still be in federal court having a federal judge deciding whether they're exonerated, completely not at fault, whether there is a limitation of liability to the 30 grand, the value of the vessel at the conclusion of the voyage, or whether or not there was liability, and then we proceed on to a trial on damages. I hope that answers your question, Your Honor.
You have, Mr. Munch. Thank you.
I would respectfully submit that the federal cases involved and the case that the trial judge really only relied on the Yang case, and that was a report and recommendation. However, if we look at and that went up to the federal district court judge in Guam, and he didn't even agree with the trial court. He said, assuming that Majestic Blue, that's the ship owner's conduct in the limitation action towards plaintiff, is inconsistent with a right to compel arbitration, plaintiffs had not established a prejudice resulting from the inconsistent acts. In other words, the one case that was relied upon by the state trial judge in staying the case, in dismissing the case and sending to arbitration, really was even reversed by the federal district court judge on the finding of the limitation action being inconsistent with the right to arbitration.
You're at the conclusion of your rebuttal time now, Mr. Munch.
Thank you, Your Honors. I appreciate the time.
Thank you both very much. And remember to leave our virtual courtroom. You click the leave button in the lower right-hand corner of the Zoom screen.
Have a good day.
Thank you.